There are really four types of alternative dispute resolution in family law. When we talk about alternative dispute resolution, or ADR, those are alternatives to court. So in family law, you can use mediation, arbitration, parenting coordination, or collaborative law. I myself work as a collaborative law practitioner. I take my role as a collaborative practitioner quite seriously. I try to do what I can to advocate and promote collaborative practice within the Lower Mainland. I do that primarily by being a board member of the Vancouver Collaborative Divorce Group, and as well I'm a charter member of the BC roster of collaborative professionals, which helps promote collaborative practice throughout the whole province. Collaborative law is really a new alternative to people who are going through a separation or divorce. They hire lawyers, therapists, and other professionals who are all trained in a non-adversarial way of resolving family law disputes. It's much more private. It's done in the context of a separation agreement. It's not in court. People will sign a specific contract. The lawyers and the therapists and the clients sign the contract together that they're all going to commit to resolving this process, not to go to court, have open, full, frank disclosure, have honest discussions with each other, and really try to put their best foot forward to resolving their dispute. In a collaborative model, you're hiring one business valuator, you're having one financial neutral help. You may have a child specialist who meets just with the children to bring the children's voices or the children's views to the table of the discussion. So it really is taking the fighting back and forth with each other, fighting through court procedure, putting that aside and saying, what plan can we as professionals put together for this family so they can move forward? A few years ago, I would say that most people who came to a family lawyer really didn't know what collaborative practice was. I'm now finding that people are more aware of collaborative practice and are coming to see me or other members of our group who are trained as collaborative lawyers with a specific question in mind as to whether a collaborative practice is good for them. And really the answer to almost all of the situations is yes. If a party is relatively amicable and they have only a few assets to divide and they don't have children, likely a collaborative practice model is going to be too much for what they need. But for a traditional family case where there's assets to divide, there's support issues to deal with, and there's children's issues as well, having a team approach with lawyers and counselors and therapists and even financial planners working together with the family in a collaborative model really does help move those cases forward outside of the court system as an alternative. And fortunately, about 90% of the cases that start as a collaborative file will finish as a collaborative file. So only about 10% of the files, it may not be at the end of the day the right choice for them, but at least they've given an alternative a try. And really, if you think about it, 90% of the people who've tried have had success, and that's a pretty good success rate in my books.